Okay, so uh, our objective for today is to finish the obligations of the vendor. So we're in the last part naman na, and we will finish the obligations of the vendor. Then after that, I will discuss action for breach of contract. I'm not sure if maabot natin ang extinguishment of sale before kayo mag-finals. So probably, yung coverage ng finals nyo would be, I will think if isama ko pa yung prelims or midterms, but for your finals subject, these obligations of the vendor, actions for breach of contract or extinguishment of sale. Okay, so let's begin. We've discussed eviction before, if you attended my last discussion, and now we'll proceed to a case of partial eviction. Okay. Okay. Under Article 1556 of the Civil Code, should the vendee lose by reason of the eviction a part of things sold of such importance in relation to the whole? So meaning that part that is lost is of such importance in relation to the whole na kapag wala daw yung parts na yun, the buyer would not have bought such thing without the said part. Then the buyer, if that part is lost, okay, by reason of eviction, the buyer may demand for rescission of the contract. So one of the remedies is to rescind the contract. But it says here, with the obligation to return the thing without other encumbrances that those which it had when he acquired it. Meaning, let's say for example, this is a case na the thing or the thing sold is already in the possession of the buyer. Okay? And the thing is lost, or the part of the thing is lost, and this part is of such importance na kung wala itong part na ito, hindi bibili ni buyer. The buyer may rescind the contract, pero the buyer will return the thing. Why? Because essentially you are going to cancel the contract. Okay? Meaning there is an obligation for you as the party having the thing to return that which you had received. Okay? That is the remedy of rescission. Pero, if you are going to return the thing, you return it exactly at the same state as you have received it. Diba? If you receive that thing without an encumbrance, dapat pag binalik mo yan, it has no encumbrance in it. Walang burden. Okay, that is the remedy for rescission. Are there any other remedies by the buyer? Yes, there are. Okay, the buyer can hold the vendor liable for eviction. Okay, meaning hindi niya na ibabalik yung thing, pero the seller is liable for eviction. So, all in all, Article 1556 speaks about partial eviction. In case of partial eviction, the buyer has two remedies. The first remedy is rescission, wherein the buyer will cancel the contract, and with canceling the contract, the buyer is bound to return the thing without any encumbrance to the thing. Okay? Or he may hold the vendor liable for eviction. Okay, those are the two remedies in case of partial eviction. Okay, that is the first and second paragraph of Article 1556, which speaks of partial eviction. Ito namang third paragraph, okay, it applies only the concept of partial eviction. Bakit? Let's read. When two or more things Dito, sa third paragraph, two or more things. Okay? Sa first and second paragraph, when a thing is sold and part of it, let's say for example, this part is lost, okay? Yan yung partial eviction. Dito naman kasi, when two or more things are sold jointly, sabihin na sold sila together for a lump sum price or for a separate price, but it should clearly appear that the vendee would not have purchased one without the other. So same conditioning with that, with the partial eviction wherein the part of the thing is lost and without that part, the vendee would have not would have not bought that thing. Same as in this case, if nawala yung isang thing, okay, although hindi siya part ng ibang thing, okay, but they are sold together, if nawala ito by reason of eviction, okay, then there is a condition that the buyer would not have bought the other two things, okay, if wala itong isa. Okay? So, para siyang integral part nung whole. So, parang set. Kumbaga, set ang binili niya. Kung wala ito, hindi niya bibilhin tong dalawa. Okay? So, same principle is going to be applied in this case para siyang partial eviction, meaning that the buyer has remedy, which is number one, to ask for rescission of the contract, and number two, to hold the vendor liable for eviction. Okay, that's Article 1556. Discussion. We have discussed this already. In case of partial eviction, the vendor can still return a portion of the remaining object of sale. Thus, of course. Okay, as long as you can return the portion of the thing, di ba? Hindi naman pwedeng you are going to ask for rescission but you are not going to return the thing. Rescission nga eh. Meaning, you are going to cancel the contract. Okay? In a sale transaction, di ba? The buyer, the seller delivers the thing. The buyer pays for the price, di ba? Pays the purchase price. If you are going to cancel or to rescind the contract, then you are going to undo everything. You are going to return the thing. Of course, the seller will return the price. Yun lang yun. Okay? As simple as that. That is rescission. Article 1557. I have elaborated this one last meeting. The warranty cannot be enforced until a final judgment has been rendered, whereby the vendee loses the thing acquired or part thereof. Meaning, this pertains to enforcement of warranty. So when and how can we enforce warranty? When there's already a final judgment and that the buyer already lost the thing because of eviction that is brought about by the final judgment. Okay? So when we say final judgment, okay, this is a decision by the court that has already attained its finality. What do we say when the judgment or the decision has attained its finality? Okay? To give you a clearer understanding, let's say for example, under the hierarchy of courts, para meron kayong knowledge, under the hierarchy of courts, okay, you have the Supreme Court at the top. This is the basic, but the hierarchy of courts is very complicated. But this one, kasi nga, we're under theory, okay, and you're under undergrad pa lang. So this will settle for this simple basic hierarchy of courts. We have the Supreme Court, the Court of Appeals, the Regional Trial Court, and then the municipal trial court. Okay? Let's say, for example, a decision has been rendered by the municipal trial court for eviction. Okay? For eviction. When the judgment comes out, hindi siya automatic na final judgment. Okay? Even if there's already a decision by the court. Okay? This judgment has to attain finality. What do you mean? When the losing party, of course, it's a case. There's a winning party, there's a losing party. If the losing party receives the decision, the losing party, okay, has a certain period of time on which he can file for an appeal. Okay, he can file for an appeal. Meaning, let's say for example, an example of period 15 days. 15 days for the losing party to file for an appeal. Okay, this period, okay, must be utilized by the losing party in order for the judgment to not become final. Okay, when the losing party fails to file an appeal within this period, okay, the judgment becomes final. Okay, hence, if the losing party exercise his right of appeal, okay, and he has appealed to the regional trial court, the judgment will not yet become final. When the regional trial court issues a judgment on the case, the judgment is not yet final. Okay? Meron pa ring period to file an appeal. Okay? And the losing party, okay, must file for an appeal. If not, the judgment becomes final. If the losing party appeals, hindi pa rin final judgment. Okay? Kapag nagdesisyon ng Court of Appeals, hindi pa rin final judgment. Okay? The party can still appeal until the Supreme Court issues a judgment. Okay? Although this one, meron pa rin period to attain finality. Okay? That's why when a judgment has been issued by the court, hindi siya kaagad magiging final. It has a certain period before the judgment will attain its finality. Okay? And that's only the first consideration. The second consideration is that the buyer has been evicted of the thing or already loses the thing. Okay? Meaning that the judgment has been executed. Okay? Kapag dito sa una pa lang, balik tayo sa MTC. Kahit pa mag-appeal yan, pwede nang magpa-execute. Okay? Unless ipa-stop ni winning party or any losing party execution. Okay? Basta there are two conditions under Article 1557 that there is already a final judgment and that the buyer already lost the thing he had acquired or a part of it has been lost already. Okay? What is a final judgment? A court last action that settles the rights of the parties and disposes of all issues in controversy except for the awards of cost and enforcement of the judgment. That's the meaning of the final judgment. Okay? Article 1558, the vendor shall not be obliged to make good the proper warranty unless he is summoned in the suit for eviction at the instance of the vendee. Meaning, generally, the vendor cannot be liable for warranty unless he is summoned in suit for eviction at the instance of the buyer or the vendee. Okay, meaning, let's say for example, A sold sold a parcel of land to B. Okay, here comes D. Okay. D now suddenly claims that he is the owner of the said land. Okay, D now files an action in court, okay, against B. Let's stop right there. Okay, because of the case that is filed by D, the party liable is only B. He is only liable to D because yun nga, ang kiniklaim ni D, siya ang may-ari. Okay? B can be evicted, B can be liable to D. Okay? What can B do? Okay, in order, kasi nga, binili niya lang naman yan kay A. Hindi niya naman in-expect na merong other party na magkiklaim ng kanyang property, nabili niya yun, kakabili niya yun. Okay? B can implead A para masama siya dun sa case. If this happens, ito na yung 1558, meaning the vendor is now obliged, okay, or the vendor can now be liable for warranty. But without B impleading A, hindi magiging liable si A. Dapat isasali siya sa kaso. Yun lang ang gustong sabihin ni 1558. As simple as that. Kailangan maisali sa case si seller or si vendor para maging liable. Simple as that. Yung Article 1558. Article 1559, the defendant vendee, the buyer, shall ask, within the time fixed in the rules of court for answering the complaint, that the vendor be made co-defendant. This is in harmony with 1558. Under 1558, we have to implead A. Okay, when you implead A, you are impleading A as a co-defendant. Okay, you are impleading A as a co-defendant, but hindi lang yun, dapat within the time fixed in the rules of court for answering the complaint. Okay, let's say for example, let's go back to the same picture. A sold to B, D. Okay, when D files a case in court, he files a pleading or a document prepared by a lawyer. That is called a complaint. Okay. Yan yung fina-file ni D or filed by his or her lawyer. Okay? Ngayon, when the court receives this complaint and the court finds nothing wrong with the complaint, kasi when the court receives the complaint, the court can dismiss this complaint if the court finds that dismissible yung complaint. Okay, pwedeng i-dismiss. But if the court, but if the court gives due course to this complaint, he will summon B, the defendant. Okay? And B is required to file a what we call answer. Tawag dyan, answer. Yan ang tawag sa document na yan, answer. Okay? Dito daw sa pag-file ng answer, okay, kasi bibigyan si B ng time, ng period of time, wherein he can file his answer. Within this period of time daw, dapat ma-implead mo na si A as co-defendant. Okay? So, pwedeng isama mo na siya sa answer mo kasi nga, yung defense ni B, of course, ang defense ni B dyan, how can I be liable e binenta sa akin to ni A? Meron siyang warranty. Is liable for warranty. Okay? Yan yung magiging defense mo. Therefore, you are going to implead A. Yun. Ganun yung 1558 and 1559. Okay? I hope nakuha nyo. Okay? 1560. Okay? Or what we call warranty against non-apparent burden or servitude. Warranty against non-apparent burden or servitude. Let's start. Article 1560. If they movable. So, let's stop right there. When we say immovable, real property or yung land building. Okay? Yan lang ang subject ng Article 1560. Kasi ang sabi niya dito, if the immovable sold. Therefore, if the thing that is sold is not a movable property, you don't apply this article. Okay? Should be encumbered. Encumbrance is, as we call it, it's a burden or servitude or a liability imposed on a certain property, be it a real or personal or immovable or movable property. But this time, the concern is movable. With any non-apparent burden or servitude. Okay? We already had an idea of a burden or servitude. Okay? When we say non-apparent, okay, hindi kita. Diba? Non-apparent. Compare that to an apparent. Nakita. Ito, it is not visible. Hindi siya kita. Not mentioned in the agreement, meaning, this non-apparent servitude, hindi na nga siya kita, hindi pa siya kasama sa agreement. Okay, not mentioned in the agreement of such a nature that it must be presumed that the vendee would not have acquired it had he been aware thereof. Meaning, the buyer has no knowledge of it, but it can be presumed that if the buyer, if he had knowledge of it, he would not have bought that property. Okay? The buyer now may ask for rescission, okay, of the contract or indemnity or what we call damages. So, after that that sentence, so the first sentence of Article 1560 speaks about warranty against non-apparent burden or servitude wherein in a sale of an immovable property wherein it has a non-apparent burden or servitude, hindi nakikita na burden or servitude. Okay? Hindi rin kasali sa agreement. Okay, the buyer has no knowledge of it, but it can be presumed that if the buyer had knowledge of it, the buyer would not have bought it. Then the buyer has two remedies, which is number one, rescission. Number two, indemnity or damages. Of course, if you are going to go for rescission, you are going to return the property. Balikan kayo ng nakuha ni buyer at ni seller. Okay? For indemnity or damages naman, hindi niya na ibabalik yun, pero kukuhanan kanya ng damages, which is in a monetary consideration. Okay? However, neither right can be exercised if the non-apparent burden or servitude is recorded in the registry of property. Meaning, okay? So, general rule, buyer has two remedies in case of non-apparent burden or servitude, rescission and indemnity or damages. Except if that non-apparent burden or servitude, okay, has been recorded in the registry of property. Meaning, if there's a non-apparent burden or servitude, the buyer has two remedies. But if it's recorded, he has no remedies. Okay? The sale is proper. Okay? Why? Because the property is recorded in the registry of property. What do you mean when say it is recorded in the registry of property? When a transaction has been recorded in the registry of property, okay, there's been a lot of jurisprudence that registration is equal to knowledge. Registration in the registry of property is equal to knowledge. Meaning, babalik ka ngayon dito. Sabi natin kanina, the buyer is not aware of the non-apparent burden or servitude. But because of recording or registering in the registry of property, this non-apparent burden or servitude, therefore, hindi mo na pwedeng sabihin na the buyer is not aware because it is recorded in the registry of property. The buyer is presumed to have knowledge. Okay? That is registration. Yan yung significance ng registration. Paano yung registration? Okay? Since we are talking about lands and building, di ba? Meron niyang title. Okay, may title yan. Doon sa titulo, doon mo ipapa-annotate yung non-apparent burden or servitude. Pag nailagay mo yun sa likod ng title, okay, that would serve as a notice or a knowledge to everyone. Actually, it's a notice to the public. Okay, this is a notice to the public. Meaning, even though you are not aware of that registration, there is an assumption of law or presumption in law na you are aware. Okay? You are aware. You cannot raise the defense. Aware ka because of that mga notice. Kapag nagbabasa kayo ng dyaryo, may mga nakikita kayong notice to the public, that is publication. Okay? That is equivalent to registration naman, meaning it puts notice to you. Kahit hindi mo binasa yung dyaryo na yun, that is notice to you because you are part of the public. Okay? That is an effort done by the party to ensure that you are informed. Okay? Yan yung notice to the public. That is similar to the principle in law na ignorantia legis non excusat, or ignorance from law excuses no one from compliance therewith. Okay? Meaning, even though, let's say for example, kayo, pinanganak kayo ng 2000s, 2001 or 2002. Okay? Let's say for example, may nilabag kayong law na enact. This law, itong nilabag nyo na law na enact pa noong 1990 or 1980, hindi pa kayo buhay. Sasabihin nyo ngayon sa nanghuli sa inyo or kapag mating sa court, sasabihin nyo sa court, I cannot be made liable for that because I don't know that law. Okay? How can I be made liable? I'm not aware of that law. You cannot do that. Okay? Why? Because of the presumption that ignorance of the law. excuses no one from compliance therewith. As long as there is complete publication of that law, meaning nung 1990 na i-publish yan sa dyaryo, okay, at nag-take effect, you are deemed to have known that law, even if you are only born now. Okay, that is ignorantia legis non excusat. Ignorance of the law excuses no one from compliance therewith. Okay? That's why being a citizen is not just being a citizen, it's being a responsible citizen. Okay? Kaya hindi kayo pwedeng tumawid sa kalsada or hindi kayo pwedeng magsasayaw sa kalsada na nadaanan ng sasakyan. Kasi bawal yun. Okay? Magbumukha kayong tanga doon kahit pagano kayo kagaling. Ba't ka sasayaw sa kalsada na ang dumadaan is sasakyan? Okay? Ganun yun. Ignorance of the law excuses no one from compliance therewith. Okay? So that is the first exception. That's only the first exception. There is an exception to this exception. Okay? Sabi dito, unless there is an express warranty that the thing is free from all burdens and encumbrances. Okay? There's an express warranty that the thing is free from all burdens and encumbrances. Okay? So, reading this one, we know express warranty naman, di ba? Affirmation of fact. Di ba? Meaning, sinabi mo na ito, hindi, wala itong burden. Wala itong non-apparent burden or servitude. Malinis itong property na to. Malinis itong property na to. Okay? May warranty ka na, may sinabi ka na ganun. And the buyer relied on that. Ibig sabihin, kapag the buyer relied on that, babalik tayo sa square one. Babalik tayo sa general rule. Ibig sabihin, nakaregister na nga yung property sa registry of property, nagbitaw ka pa ng affirmation na walang burden at encumbrances, babalik tayo sa square one wherein buyer now has the remedy to rescind or ask for indemnity or damages. Di ba? There's an exception to the exception. Okay? So, reading paragraph 1 of Article 1560 as a whole, in case of a sale of an immovable property wherein it has a non-apparent burden or servitude which the buyer is not aware, and the buyer, if he is aware of that non-apparent burden or servitude, the buyer would not have bought that property. The buyer will have, under the general rule, the buyer will have two remedies, which is to ask for rescission or to ask for indemnity or damages. But those two remedies cannot be exercised if the property is later on found out to be registered in the registry of property. In that case, the buyer will now have no remedy. Okay? But even if that property has been registered in the registry of property, okay, if the seller later on, okay, provides an express warranty that the thing that he is selling is free from burden and encumbrances, okay, then we'll go back to the general rule. The buyer can now ask for rescission and indemnity or damages. Simple as that. That is Article 1560. Okay? The second paragraph is the prescription. Okay? Within 1 year to be computed from the execution of the deed of sale, the vendee may bring the action for rescission or damages. Meaning, within 1 year, the buyer can ask for rescission or damages. If naglaps ka ng 1 year, okay, more than 1 year, you can only ask for damages. Where is that? That is the third paragraph. Okay? So that is Article 1560. We have not yet given an example of a non-apparent burden or servitude. To define a servitude, it is an encumbrance imposed upon an immovable. So take note, this is an encumbrance imposed on an immovable, dun sa property, sa immovable property, for the benefit of another immovable, for the benefit of another property belonging to a different owner. Take note, to give you a clear example of a burden or servitude, we have this example. Let's say, for example, this is a road, national road, provincial road, whatever you call it. This is a road. Okay. Let's say, for example, there are 2 parcels of land adjacent to that road. This one is a river. Bridge na ito. Okay, this one is a river. So water yan. This property right here is owned by Mr. A. Hindi kayo malito. This property right here is owned by Mr. B. Okay? Let's say, for example, these are trees or forest na ito, mga puno-puno. Pati itong likod na, puno-puno na yan. Okay? A can access the road. Why? Because A is adjacent to the road. Diba? Simple as that. Katabi niya yung road, can access the road. But B, as the owner of the property behind the property of A, he cannot access the road. Why? Saan siya dadaan? Daan siya kay A? Property yan ni A. Daan siya sa gubat? Bawal basta-basta pumutol ng puno. Ano din, magbabangka siya papunta sa kalsada. Okay? Because of these complexities and realities happening, okay, there is what we call, meron tayong tinatawag na mga burdens or servitude sa property. And an example of this one is what we call right of way. Right of way. Let's go back to the definition of servitude. Okay. Servitude is an encumbrance imposed upon an immovable. Itong right of way, this is an encumbrance. So if it is imposed upon an immovable, we apply it to this case. It is imposed on the land of A. So that's the first part. For the benefit of another immovable belonging to a different owner. Okay? It is made for the benefit of B. Why? For B to access the road and to have an egress or ingress, diba, to the road. Yan yung right of way. It is a burden. Kaya nga natin sinasabi kanina, a burden or a servitude. Burden siya sa immovable, sa property ni A. Why? Because si A sana, ito sana yung area ng lupa niya. Oh. Diba? You can see naman. Pero because of this right of way, ito na lang ang area ng lupa niya. Okay, because of this right of way. This is a burden imposed on A because of B, for the benefit of B. Okay? Right of way. Para makadaan si B, i-impose yang encumbrance or burden or servitude na yan. Okay? That is a burden or servitude. Okay? I hope that is clear. Wait lang, charge ko lang. Laptop. Okay? Yan yung burden or servitude. Okay? But this right of way is an apparent burden or servitude. So, hindi ito yung tinutukoy natin sa Article 1560, which is non-apparent burden or servitude. So, anong tinutukoy natin? An example of that would be the burden imposed on properties surrounding an airport. Okay? To give you a clear view, wait lang. Okay, to give you a clear overview, dyan na lang sa Tuguegarao City, sa airport, you notice all of the buildings there or the houses are at a certain height. Wala kang makikita dyan na sobrang taas na building. Di ba? Yung Brixton na lang. Pansinin niyo yung height niyan. Tapos yung mga katabi niya na building, especially yung Robinson. Di ba? At a certain height. And we all know Robinson's corporation, di ba? Usually, enormous ang mga buildings niyan. But in that case sa atin, hanggang second floor lang. Okay, at a certain height lang. Okay. This is what we call a non-apparent burden or servitude. Why? Because, hindi ko alam mag-drawing ng airplane. Ayan, di ba? Airplane. This is because to give way or clearance to the airplane para mag-land. That's why ganyan yung height ng mga buildings and houses dyan because of this non-apparent burden or servitude. Hindi siya kita. Hindi siya kita pero hindi siya kita na burden or servitude. Kaya kapag nag-exceed ka niya, hindi ka papayagan ng Tuguegarao City na mag-build ng building higher than a certain limit. Hindi ka i-allow. Maglabas ka pa lang ng permit, hindi ka na i-allow. Why? Because of the existing burden or servitude near the airport. Okay, and that is legal. Okay, that's legal. Hindi yan against sa rights mo. Okay? Kasi ngayon, people right now, when we say right, you must enforce it. You must claim it because it is your right. Yes, that could be your right. But take note that in exercising your right, you also have an obligation to respect the rights of others. Hindi ibig sabihin ikaw may right yung katabi mo meron ding right. If you understand that purpose or if you understand that reasoning, then you know that a right is not exercised to the detriment of another person. You have the right to enjoy. Ngayon, mag-enjoy ka. Magpa-party ka hanggang madaling araw. Ang lakas-lakas ng tugtog ah, ng music mo to the point na disturb ang neighbors mo. That is your right na mag-enjoy. But you must be aware that in enjoying your right, you must also consider others. Hindi pwedeng mag-enjoy ka to the point na meron kang mga bastos or may masira ka na tao. Okay? Okay. Sige. Subsection 2. I hope that's clear. That's non-apparent burden or servitude. You cannot see that in the titles na bibilhin mo. Okay? Unless pinaregister yan. Okay? So kung pinaregister yan, balikan mo sa 1560. In-apply natin kanina. Okay? Basta kapag non-apparent yung burden or servitude, yan ang i-apply mo 1560. But if it is an apparent burden or servitude, there's no way na hindi mo ito mapapansin itong right of way. So kapag binili mo itong lupa ni A, pansin mo yan. Okay? Kasi kapag binili to, hindi naman pwede na mawawala itong right of way. The right of way attaches to the property permanently. Sa kaso, madaming nagkakaso dahil dito pinapasara yung right of way which has already been established long time ago. And usually, sinasali na yan dun sa plan. Okay? Now, we're done with warranty against eviction. Let's now go to warranty against hidden defects or faults or encumbrances upon the thing sold. Okay? Let's proceed with Article 1561. The vendor shall be responsible for warranty against hidden defects which the thing sold may have. So, dito parang sa phrase na to, the vendor is liable for warranty against hidden defects. Okay? Should they render it unfit? Okay, meaning the hidden defects should render the thing unfit or diminish its fitness for such use to such an extent that had the vendee been aware thereof, if the vendee would have been aware thereof, he would not have bought that property or he would have bought it at a lower price. So, dun pa lang sa first phrase nitong Article 1561, okay, a hidden defect, okay, must render the property unfit or it must diminish its fitness. Okay, if that's the case, the buyer must have not been aware of it. Okay, or else he would not have acquired it or have given a low price for it. Okay, so there are instances kasi na there are hidden defects but it does not render the property unfit. There are hidden defects but it does not render the property unfit. Just like minor scratches, di ba? Or because of normal wear and tear or because of conditions, weather conditions, may mga unknown defects. But sometimes, it may not render them unfit. Pwedeng it may diminish its fitness. If that's the case, you can buy it for a lower price. Okay? But, sabi dito, said vendor shall not be answerable. Hindi daw liable si vendor in case of, number 1, patent defects. When we say patent defects, they are visible or those which are visible, meaning kitang-kita mo. Okay? Let's say, for example, nagbenta ka lang sasakyan. But this is brand new, hindi yung mga second hand. Okay? Nagbenta ka ng sasakyan na brand new. Napansin mo, nung chinek mo, wala siyang spare tire. Okay? Dapat mayroong spare tire. Okay? Yan, mga kulang, patent defects. Or, napansin mo na hindi gumagana yung lights. Yung turn signals or yung hazard lights hindi gumagana. Okay? Papansin mo naman yan pag in-inspect mo na yung property bago mo siya kunin. Okay? These are patent or visible defects. Or, even if they are not visible, but the vendee is an expert and should have known them. Okay? Meaning, let's say, for example, in the case of a real estate property, may nabenta na lupa, okay? The buyer bought it. This buyer has been buying and selling lands for 15 years, sabihin mo na. 15 years is a lot of experience and knowledge in the trade, okay, na ma-acquire ni B. For that instances, B may be considered as an expert, and B should have known that there are defects in the land that he is buying. Kasi nga, you are already 15 years in that profession or in that trade. 15 years kang nagbabuy and sell, alam mo na yung ins and outs. Yung mga unwritten rules in case of buying and selling real property. You also know how to check the land. Diba? There's no excuse that you cannot determine that na hindi mo siya makita. You cannot say na hindi mo siya makita. Why? Because of your experience. Okay? So in summation, Article 1561 talks about hidden defects. That a hidden defect should be, I should render the property unfit or diminish its fitness, and should the buyer have been made aware, has been made aware thereof, the buyer would not have bought it or would have bought it for a lesser price. Okay? And it also talks about defects that are not hidden. Mga hindi siya hidden defects. These are patent defects or those that are visible, or even if they are not visible but the buyer is an expert and should have known them. Hindi siya hidden defects. If hindi siya hidden defects, the vendor is not liable. Okay? Ito na yung requisites of hidden defects. Una, the defect must be hidden, of course. Hidden defects. When we say the defects must be hidden, ibig sabihin, hindi siya visible, hindi siya patent, and that the buyer is not an expert. Kasi if patent siya, visible siya, or expert si buyer, hindi siya hidden, di ba? It must exist at the time of the sale, of course. The hidden defect must exist at the time of the sale or beforehand. Because if that defect only existed after the sale or after the delivery, hindi liable si vendor. Okay? Must ordinarily be excluded from the contract. Meaning, this hidden defect cannot be found in the contract. Okay? Kaya nga hidden. Kasi kung nakalagay na dyan sa contract, okay, ibig sabihin, pinapakita na sa'yo ni seller na meron ganitong defect. Must be instituted within the statute of limitations, meaning it talks about prescription, meaning it must be filed within the statute of limitations, meaning under this case, 6 months. We'll discuss this one later, 6 months. Requisites of hidden defects. 1562, in the sale of goods, there is an implied warranty or condition. Okay, there's an implied warranty of condition as to the quality or fitness of the goods. So this is an implied warranty on the quality or fitness of goods, or what we call warranty on merchantability. Okay, merchantability. Ibig sabihin, kahit wala sa contract, kahit wala kang sinabi sa buyer, meron tayong implied warranty as to the quality and fitness of the goods. Una dyan, where the buyer expressly, kung may sinabi siya, or wala naman by implication, makes known to the seller the particular purpose for which the goods are acquired, and it appears that the buyer relies on the seller's skills or judgment, there is an implied warranty that the goods shall be fit or reasonably fit for such purpose. Meaning, when the buyer goes to the store and buys a pair of scissors, okay, the buyer can say to the seller na, bili nga ako ng matibay na gunting panggupit ng mga folder, mga papel, okay, ng mga scotch tape, ganyan, ayan. Or, kahit hindi expressly, by implication, meaning, the fact that he's buying a scissor, he's gonna cut something. Okay? He's gonna cut something. Okay? Meaning, you as a seller, you are guaranteeing or there's an implied warranty kahit wala kang sinabi na itong gunting na to is reasonably fit for the purpose of cutting. Okay? As simple as that. That is the first paragraph under 1562. Okay? The seller is liable, or the seller has an implied warranty on the quality or the fitness of the thing. Okay? Second, kapag naman yung goods is sold or brought by description, okay? Meaning, dinescribe sa'yo nung seller. Okay? There is already an implied warranty that it is of such a merchantable quality. Okay, meaning, let's say for example, may binili kang ref, dinescribe sa'yo ni seller, pinakita pa sa'yo yung box, pinakita sa'yo yung manual or yung mga features, yung brochures, merong mga features diyan. Okay, dapat yung pinakita niya sa'yo, yung describe niya sa'yo, it must be the same with the product that you are going to get. Dapat meron siyang features na nasabi niya. Because that is one of the obligations of the vendor, that the product should be of merchantable quality. Aside from it being fit, must be of merchantable quality. Okay, that's Article 1562. Kaya implied warranty of merchantability with regards to its ordinary purpose or general purpose. Okay? You're going to buy a crayon, for example, or a color pencil. Of course, for the purpose of coloring something. Di ba? You're not gonna buy a color pencil to use as a makeup. It's not its purpose. It's not the ordinary purpose. Okay? And that, please be reminded that there is no implied warranty on second-hand articles. Meaning, if you bought a second-hand car, ay, hindi na ito kotse. O yan. Second-hand car. Sabihin mo na lang, ano ito? Bus. Second-hand car or vehicle. Okay? Wala nang implied warranty dyan on its fitness or quality. Why? Because what you see is what you get. Bago mo naman bibili nitong second-hand vehicle na to, ipapatest drive pa yan sa'yo. Titignan mo yan. Meron pa yung iba, they will allow you to bring a mechanic of your own para ma-check niya kung okay yung sasakyan. So there's no implied warranty on this one. Why? Because second-hand articles na yan. Parang may presumption na yan na ibibenta yan dahil meron na yung mga sakit or meron na siyang mga defect. Okay? Kaya wala siyang implied warranty. Unless there is an express warranty. Yun na, iba naman na yun. Kung si seller na yung nag-warrant na this vehicle is in a good condition, walang ganito, ganyan. Yeah. That is an express warranty. And you relied upon it. Okay. 1563, in case of a contract of sale of specified article under its patent or other trade name, there is no warranty as to its fitness for any particular purpose unless there is a stipulation to the contrary. Okay, meaning, in connection with Article 1562, okay, that it has a warranty with regards only to its particular purpose or to its ordinary or general purpose. Okay, but with regards to any special purpose na hindi ordinarily ginagamit for scissors or dun sa crayons or sa color pencil, okay, there's no warranty in that. Okay, unless nagbigay ng express warranty si seller. In that case, you don't apply the law in implied warranty, you apply the law on express warranty, yung affirmation of fact, the buyer relied, yan, mga ganyan. Okay? An implied warranty or condition as to the quality or fitness for a particular purpose may be annexed by the usage of trade. Okay? Meaning, if by the ordinary course of the trade or yung scissor, dapat nakakagupit. Okay? Hindi bibili ka ng gunting na hindi siya makakagupit. That's why there is an implied warranty. This is in connection with 1563, 62. Okay? You can read them as one. 1565, in the case of a contract of sale by sample, if the seller is a dealer in goods of that kind, there is an implied warranty on that seller that the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent or reasonable examination of the sample. Meaning that if you are going to sell a product by sample, syempre by sample yan. Papakita mo yan sa buyer na ganito. Sir, ganito siya, gamitin natin. Ganito. Dapat yung ibibigay mo dun sa buyer, same dun sa ginamit mo. Why? Because there is an implied warranty on its merchantability na wala siyang hidden defects. Okay? Dapat same siya dun sa ibibigay mo. Warranty on merchantability. So we have sale by description, sale by sample. Okay? Article 1566, the vendor is responsible to the vendee for any hidden faults or defects in the thing sold, even though he was not aware thereof. Meaning, general rule, the vendor is liable to the vendee whether he had knowledge or not of the hidden defect. So kahit whether alam ni seller or hindi alam ni seller na mayroong hidden defect, okay, he is liable to the buyer. But Article 1566 provides for an exemption. This provision shall not apply if the contrary has been stipulated and the vendor is not aware of the defects of the thing sold. Therefore, babalikan natin in a contract, okay, kapag walang nakalagay as to liability against hidden defects, you apply the general rule, vendor is liable to the vendee whether he had knowledge or not of the hidden defects. Magbabayad siya kay vendee. Okay? But, if merong nakalagay sa contract na contrary stipulation, meaning sinasabi dun sa contract na vendor is not liable for hidden defects. Yan ang sinasabi dun sa contract. Okay, kapag meron daw ganyan at hindi aware si vendor, vendor is not liable. Okay? That's Article 1566 as clear as that. Okay? General rule, whether the vendor has knowledge or not of the hidden defect, he is liable to the vendee. But if there's a contrary stipulation to the contract and the vendor is not liable, is not aware or has no knowledge of that hidden defect, then the vendor is not liable to the vendee. Okay, that's Article 1566. 1567 talks about remedies. What are the remedies of the buyer in case of hidden defects? So, the buyer can withdraw from the contract or demand for a reduction of price plus damages in both instances. Meaning, if there is a hidden defect, the buyer can withdraw from the contract. Ayoko na. Pwede, meron pang damages. Babayaran pa ni seller si buyer. Okay? Or, hindi siya nag-withdraw, papabawas yung price. Pero magbabayad pa rin ng damages si seller. Okay? These are the two remedies of the vendee or the buyer. In case of hidden defects na ito, sa ibang warrant, ang remedies for eviction, ibang warranty for hidden defects. If the thing sold should be lost. So, in case of lost, kapag sinabi nating lost, hindi lang nawala, pwedeng nasunog, burned, pwedeng basta yung to the point na hindi na siya malocate, basta na lost. Okay? In consequence of hidden defaults. Okay, this one is when the thing has been lost because of its hidden defect. Okay, if it is lost because of hidden defect, and yan yung unang condition, and the vendor is aware of the hidden defect, the vendor shall bear the loss. Okay. Return the price, refund the expenses, and since the vendor has knowledge, meaning bad faith, can also ask for damages. So, in case the thing has been lost because of hidden defects that the vendor is aware, the vendor shall bear the loss. Shall bear the loss, meaning nawala, ibabalik niya yung price. Okay? Pero hindi niya na makukuha yung thing kasi nga nawala na eh. Or considered as lost na eh. Diba? Okay? Return the price. Yung sabi ko kanina, return the price. Kasi nga nawala because of hidden defect, na aware siya eh. Okay? Return the price. Refund the expenses. Kung merong ginastos si buyer or si vendee, okay, ibabalik ni vendor yung ginastos niya. Plus, damages because of bad faith. Take note sabihin ko na dito. Kapag bad faith, kahit sinong party, basta bad faith, liable yan for damages. Basta bad faith. Knowledge. Okay? But if the vendor is not aware, okay, of the hidden defect, but the thing was lost because of the hidden defect. Okay? Ano lang ang liability ni vendor? Of course, return the price and interest plus reimburse the expenses of the vendee. If merong gastos si vendee, if wala siyang i-reimburse. Okay? Yun yung difference. So, This is a case wherein the property is lost by virtue of the hidden defects. Una yung in case of bad faith, pangalawa in case of good faith by the vendor. Okay. Article 1568. Article 1569. Ito naman, the thing has been lost, but it is not because of the hidden defects. It is because of fortuitous events or yung mga acts of God or through the fault of the vendee. So, ang may kasalanan, so nawala yung thing either because of fortuitous event, acts of God, or dahil kasalanan ni vendee. If that is the case, okay, the vendee may demand that the vendor may pay the price, okay, that the vendor may demand of the vendor the price which she paid less the value at the time when it was lost. So, ito yung pwedeng i-demand ni vendee. So, if putting that into an example, let's say, for example, you bought a property for 300,000 and it was lost, and the value of the property when it was lost is already 150,000. So, the amount that the vendee or the buyer can demand from the vendor is 150,000. Okay? Yun yung Article 1569. Meron pa dito sabi, if the vendor acted in bad faith, as I have said kanina, any party who acts in bad faith or who has knowledge, okay, is liable for damages. Therefore, in addition to the 150K plus damages. That's Article 1569. So, we have talked about loss in case of hidden defects and loss in case of fortuitous event or into the fault of the buyer or the vendee. 1570, this also applies to judicial sales. 1571, actions, ito na yung prescription with regards to warranty against hidden defects. Okay, ito na yung sinabi ko kanina na 6 months. 6 months from the delivery of the thing sold, dapat mag-file ka ng action for warranty against hidden defects or breach of warranty. Okay, breach of warranty ang ipa-file mo sa court. If nag-lapse yan, wala na. Hindi mo na pwedeng i-claim. Why? Because this is a hidden defect in a span of 6 months. Dapat makita mo na yung hidden defect. Okay? If 2 or more animals, let's proceed now to animals. Okay? Kanina, tapos na tayo sa things. Okay, bagay yun. Mga yun. Ngayon, punta tayo sa mga hayop. Okay, hayop. If 2 or more animals, so let's put that into illustration. Okay, since magaling tayo mag-drawing yan. Gawin natin 3, 2 or more naman eh. If 2 or more animals are sold together, so binenta sila together, whether for a lump sum price, meaning the price of the 3 animals, these animals are goats. They are sold for a single price, or they are sold for separate price for each animal. The redhibitory defect of one, meaning yung hidden defect ng isa, redhibitory defect of one, shall only give rise to its redhibition. Meaning, kung goat 1 has a redhibitory defect or hidden defect, ibig sabihin, ang sinasabi ni 1572, dapat si goat 1 lang ang merong redhibition, ang merong defect. Si goat 2, si goat 3, wala silang hidden defect kasi si goat 1 lang naman yung merong hidden defect. Okay? And not of the others. That's why sabi ko, Kung siya lang ang may hidden defect, siya lang. Hindi kasama yung dalawang kambing. But that is the general rule. This is the general rule. Exception? Yes, there is an exemption. Unless it should appear that the vendee would not have purchased the sound animal or animals without the defective one. Okay, balik tayo dun sa concept, dun sa beginning ng warranty against hidden defect or dun sa pwede mo siyang i-apply dun sa warranty against eviction, yung partial eviction. Na hindi sabi dito, generally kung may hidden defect yung isa sa binentang kambing, yun lang yung may hidden defect, hindi kasama yung dalawa. But if hindi bibilhin ni vendee yung sound animals or yung mga walang sakit or defect na animals without the one na merong defect, then that may be considered as the 3 goats to have redhibitory defect. Pwedeng consider ni vendee yun na meron silang redhibitory defect. In that case, pwede niya namang hindi bilhin. Diba? Or pwede niyang ibalik. If nabili niya na, pwede niyang i-rescind. We'll talk about the remedies later. Okay, pero ito yung sinasabi ni 1572. Okay? Kapag nagbenta ka ng grupo ng hayop, basta mga hayop yan, kung merong hidden defect yung isang hayop, siya lang yung may hidden defect. Okay? Pero kung hindi bibilihin ni vendee yung mga walang hidden defect, yung mga okay o yung walang hidden defect, without yung merong hidden defect. Okay? Ibig sabihin, pwedeng lahat sila is considered by the vendor as having redhibition. Okay? It shall also be presumed when animals are sold in teams, in yoke pairs, or in set. Okay? Even if there is a separate price. Meaning, binenta mo sila as a group. Let's say, for example, lahat ng anak ng isang baboy binenta mo, di ba? Ay binili mo. Okay. And yung isa mayroong reddivision. Ibig sabihin, pwede mong ipa-cancel ito kasi considered as whole of them as reddivision. You apply the exception kasi there's already a presumption. Article 1572. Article 1573, the same provision shall be applicable to the sale of other things. Meaning kahit hindi hayop ang binenta mo, okay, wag lang tao kasi kapag taong binenta mo, that is against anti-human trafficking. That is illegal. Okay, basta other things, pwede mong i-apply itong concept na ito. Meaning, kung bumili ka ng 3 bagay or bagay na in a group or in a pair, okay, kung yung isa is may hidden defect, hindi ibig sabihin na yung 3 meron na ring hidden defect. Okay? Kung ito lang may hidden defect, ito lang may hidden defect, ito okay. Unless, di ba, meron tayong exception, hindi mo bibilhin tong dalawa without this one. Yun, pwede mo siyang rescind. 1574, there is no warranty against hidden defect of animals sold at fairs, sa mga perya-perya, public auctions, di ba? Or dun sa livestock sold as condemned. Why? Because there is already a presumption na these animals might have redhibitory defect. That's why that's why they are sold at such instances, because there's already there's no guarantee that they have or they have not a hidden or a redhibitory defect. 1575, okay. The sale of animals suffering from contagious disease shall be void. Meaning, if bumili ka ng manok na merong sengaw, may sakit na mamatay yung mga manok, ganyan, that is a void sale. Okay? Take note, redhibitory defect or yung hidden defect sa mga hayop is not the same as contagious disease. Okay? A contract of sale of animals shall also be void if the use or service for which they are acquired has been stated in the contract and they are found to be unfit. Therefore, okay, let's say for example, bumili ka ng kalabaw, gagamitin mo kasi nga magsasaka ka. Nung binili mo siya, nakaupo lang siya or nakahiga lang siya. Okay? Nung dineliver siya, nakahiga lang siya. Okay? Nung pagdating sa farm mo, nakahiga pa rin siya. Yun pala, hindi pala tumatay yung kalabaw na yun. Kasi daig ka pa niya, mas tamad yung kalabaw na yun sa'yo. Okay? Therefore, it cannot be used for the purpose or for the service that it has been intended for. So, anong gamit ng kalabaw na yun? Display? Pag kumain, nakahiga din, nakaupo. Kaya pala hindi lumilipat sa kanyang pwesto, kaya pala siya binenta ni seller kasi nga hindi siya tumatayo. Okay? You cannot use that kalabaw. Okay? That sale is considered as void. Meaning, even if there is a sale, it can be voided. Okay? 1576, ayan. Dito lang kasi na-define yung redhibitory defect. Ewan ko kung bakit nagulo yung provision ni Civil Code. Pero dito niya di-define yung redhibitory defect or hidden defect sa hayop. Okay? Sabi dito, if the hidden defect of animals, even in a case of professional inspection, has been made, should be of such a nature that expert knowledge, take note, expert knowledge, is not sufficient to discover it. The defect shall be considered as redhibitory. That's the definition of redhibitory defect. But if the veterinarian, through ignorance or bad faith, should fail to discover or disclose it, he shall be liable for damages. Meaning, bago mo binili yung animal na yan, pina-inspect mo muna sa veterinarian. Ang sabi niya, wala. Kasi nga, ignorant siya. Meaning, when we say ignorant, okay, a person ought to know something, but he doesn't know it. Diba? Let's say, for example, veterinarian ka, dapat alam mo. Pero hindi mo alam. That is ignorance. Ibang ignorance sa innocence. Okay. Ang innocence naman, a person doesn't know something because he ought not to know it. Diba? A 2-year-old child, a 4-year-old child, okay, is innocent with regards to mature stuff. Okay? Why? Because they are just toddlers. Ang ignorance, you ought to know it. Dapat alam mo. Pero hindi mo alam. That's ignorance. Bad faith, you have knowledge. Meaning, si veterinarian, alam niya na may sakit yung hayop. Pero dahil sabi sa kanya ni seller, sabihin mo walang sakit yan. Bigyan kita porsyento ng kita ko. Sinabi niya dun sa buyer, walang sakit yan. That is bad faith. Therefore, you are liable for damages. Okay? 1577. Ito na yung talks about prescription. Okay? The redhibitory action must be brought within 40 days. O, napakaliit. 40 days from the date of delivery to the vendee. Okay? Kasi nga, within that span of time, makikita mo na yung redhibitory defect. Dapat makita mo na siya. If nag-lapse yan, your action for redhibitory action is already prescribed, hindi mo na siya pwedeng i-file sa court. Or, pwede mong i-file sa court, but it can be dismissed. Why? Because the action is already prescribed. This action can only be exercised with respect to faults and defects which are determined by law or by law customs. 1578, if the animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused the death existed at the time of the contract. Okay? Dito sa 1578, it does not guarantee that if the animal that you recently bought died within 3 days, hindi automatic na liable si vendor. Okay? Dapat, you must prove that the reason for the death of that animal existed before the sale or at the time of the contract. Dapat nag-exist na yung cause of death ng animal. In other words, kapag namatay yung hayop within 3 days ng pagbili mo, hindi ka agad liable si vendor. Liable siya kapag ma-prove mo sa court na yung cause of death existed before the sale or during the time of the sale. If it existed after the sale, a day or two or within the third day, nag-exist yung cause of death, the vendor is not liable. Diba? I'm saying this one because alleging something and proving something is different. When you allege or you claim na namatay siya because nag-exist yan before or during the time of sale. But you need to prove it. And that is different from alleging something. When you prove it in court through evidences. And iba yung pag-prove sa pag-allege. Okay? Because sabi nga natin, meron tayong the ultimate truth. Meron kang ultimate truth. Meron ka ring truth that you can prove in court. Although ideally speaking, guys, we want this. But there really are circumstances wherein we cannot prove some things in court or mahirap siyang i-prove in court. Okay? Pwede mo lang naman ma-prove yung thing because of evidences. If you don't have evidences, you don't have a basis for your claim. Let's say, for example, in a dark place, isolated. Tignan mo yung bag. Ginasgasan nila. Okay? You are in an isolated place. Let's say, for example, A and B are in an isolated place. Okay? It's night time. Isolated place, meaning kahit sumigaw ka, walang makakarinig sa'yo. Walang taong nakakita. Madilim. Kung may makita man, mahirap makita. Okay. A suddenly shot B. Point blank, binaril niya si B. B died because of that incident. No one ever saw that. Okay. And the body of B is only discovered, let's say, a week after. Okay. So medyo naagdas na. Okay. In the first place, there's a crime. That one I can assure you. Because there's a body. The body is an evidence that there is a crime committed. The question now is, who do you indict? Sino ang kakasuhan mo? Take note of the circumstances. It's night time. You are in an isolated place. How can you determine who killed who? Okay. The ultimate truth, because this is an example, is that A killed B. Yan yung setting natin. But if you are a lawyer, okay, and this case has been handed to you, hindi mo alam kung sino pumatay. In the first place, how will you prove it? Okay. Ito wala kang knowledge na si A ang pumatay Okay? Basta ang natagpuan nyo lang is yung bangkay lang ni B. Wala na. Ayun lang. Of course, start from the scratch, di ba? Yung bala na ma-recover, i-trace nyo, di ba? Ano pa, kung meron kayong ibang evidence na makita sa crime scene, okay, trace nyo. Kung wala talaga, you look at the motive. Sino ba yung possible suspects na merong galit kay B? Diba? That's all you can have. And hoping na this evidence would give you the ultimate truth. Okay? Kaya mahirap maging abogado din. Okay? Because not all the time you have the evidence. Okay? This is very significant kasi nga, let's say for example, ito in example ko ito sa pari when I was connected with Legal Network for Truthful Elections. In example, itong case na ito sa pari. Ang sabi lang nung pare, kaya nga si A ang pumatay. Bakit hindi nila kasuhan si A? Si A ang pumatay, sabi niya. In the first place, before you go to the conclusion that A killed B, you must have evidence that A killed B. In the example, ang sabi lang, A killed B. Pero ang sabi lang ni pare, A killed B. Dapat siya ang kasuhan. But you cannot arrive to that immediate conclusion na A killed B. Because you don't have proofs that A killed B. Hindi naman tayo law of men. Now, when we point at someone, siya ang pumatay, siya ang pumatay. You need to prove. That's why there's a justice system. Paano kung ikaw na walang kinalaman, kahit pagalit ka kay B, gusto mo siyang mamatay? Or sa isip mo, matagal mo na siyang pinatay-patay. Tinatagtad mo ng bala sa isip mo. Pero hindi ikaw yung pumatay. Pero lahat ng motive nasa iyo. Ikaw ang kinasuhan. How can you defend yourself? Kung yung public alam na ikaw ang pumatay. Pero in truth, hindi ikaw si A. Ikaw si C, ikaw si D. Okay? That's why there are two sides of the coin. Prove something. Nasayop lang tayo kung pumunta tayo sa proving something because very important yan sa 1578 na kapag namatay yung hayop within 3 days, hindi automatic liable si vendor, hindi. I-prove mo muna na yung cause of death, una muna, anong cause of death? I-prove mo muna na yung cause of death na yan existed nung binili mo siya or existed bago mo siya binili. Kasi kung hindi mo yan ma-prove, hindi liable si vendor. Okay? Si vendor walang liability na i-prove na nag-exist yan after. Ikaw na buyer na nagsasabi na nag-exist yan before the contract or during the contract, ikaw ang magpo-prove na nag-exist yan. Si vendor wala siyang liability. Okay? That's 1578. 1579. This one is similar dun sa action for rescission. Pero sa animals nga lang, if the sale is rescinded, of course, the animal shall be returned. Okay, but the animal shall be returned in the condition in which it was sold and delivered. Kung ano yung condition niya nung na-deliver sa'yo, dapat ganun din siya pag ibabalik mo. Why? Because the vendee is liable for any injury due to his negligence and not arising from the redhibitory defect. Therefore, if you ask for rescission and you return the animal and it's later found out that it has an injury, okay, there are two things that can happen. If it has an injury because of redhibitory defect, okay, hindi liable si vendee. If it's an injury because of your negligence, liable ka na buyer, na vendee. Liable ka. Okay? Di ba? Kapag binili mo yung baka na yan o yung kambing na yan, na apat ang paa, ibalik mo yan na apat ang paa. Hindi mo pwede ibalik na tatlo lang ang paa. Okay? Hindi mo rin pwedeng ibalik yung palitan ko na lang ng ibang kambing. Okay? Why? Because hindi naman yun yung binenta sa iyo. Kaya pinaparesin, pinapabalik mo yun. Unless itong i-offer mo na kambing, gusto ni seller. Okay. Take note na, hindi tayo legalist. We want harmony. Okay, that's why we just like in the civil code, if both parties will agree to something, then that will bind them. As long as it is legal, it's not contrary to law, to morals, pwede yan. Hindi naman pwede na, nag-agree sila, bininta nila yung anak nila. Hindi pwede yun because that is against the law. All your agreements should be not contrary to law, not contrary to morals, to good customs, okay, to public policy. Okay? 1580 is the remedy in case of hidden defects on animals or redhibitory defects. This one is similar to remedies on hidden defects. Okay, so for animals and things, same remedy. The first one is withdrawal plus damages, as I have discussed kanina, and the second one is reduction of price plus damages. Okay, and the last article, the form of sale of large cattle shall be governed by special law. Okay. So, ibig sabihin, kapag nagbenta ka ng anything that is considered as a large cattle, okay, mga kabayo, baka, kalabaw, meron niyang formality. Ibig sabihin, meron niyang prescribed form. Pero, with regards to its essence or to the principles involved, ang mag-a-apply pa rin sa civil code. Itong special law na to, it's because of the anti-cattle rustling law. Meaning, before kasi madaming mga ninakaw ng mga kalabaw, mga baka, kabayo. These are large cattle. Okay? Siyempre, naka-stray lang yan sa daan or sa gubat or sa farm na walang nakabantay, kinukuha. Okay? Kapag nahuli ka na meron kang ganyan, na wala kang hawak na papel, o parang ano rin yan, property, may title, or parang merong birth certificate yung mga yan. Pag nahuli ka na ganyan, na wala kang hawak na papel, that may be in violation of the anti-cattle rustling law. This law is enacted because of those scenarios na mga nangyayari, na mga kinukuha-kuha. Okay? That is Article 1581. So that is the last article under obligations of the vendor. We'll proceed next time to obligations of the vendee. Okay? Any questions? Okay, I've been informed that your exam is face-to-face. So, But I may not be able to meet you, so substitute proctor siguro. So kung wala na exam, let's call it tonight. Good night, everyone. Good night, class.
Thank you po, attorney.
Goodbye,
Thank you,
sir.
sir.
Po, sir.
Thank you, sir.
Thank you, sir.